Here, before we do the defense and state, we have agreed, in light of the defense's objection for Exhibit 311, the state and defense, we have...
Satisfactory with us.
All right, very well. That's the action form we
for the record, I'm going to remove the original. I'm just trying to make sure that's going to go back and this does not.
All right, the original is being removed from the record, and the redacted versions is going in.
State's ready.
State ready.
Yes, ma'am.
Well, all you're going to do is introduce the exhibit. That's correct.
I'm sorry.
All you're going to do is introduce the statements of the federal court testimony, and then you plan the rest. Is that correct?
Yes, sir. If Your Honor was going to permit me, we were going to read it into the record.
For sure, that's fine.
And then I've got the defense has agreed to let the state move into evidence 3 pictures that we've not moved in. And then after that, yes, sir, the state was fine.
That's fine. Then we'll probably send the jury back into that point. We'll do this. All right. Great. You can be seated. State waiver call? Yes, sir. Defense waiver call?
Yes, sir.
Welcome back, ladies and gentlemen. Ladies and gentlemen, if any of you were approached or engaged by anyone trying to talk to you about this case from the time you left the courtroom on Friday until this moment, please raise your hand. If anyone has tried to present any information to you regarding this case in any form whatever, please raise your hand. No one has raised a hand. All right, gentlemen, proceed.
Okay, first we'd like to move into evidence 303, which is a photo of Miss Kadiatu Kamara. Exhibit 304, which is a picture of Mr. Roy Thurman. And Exhibit 306, which is a picture of Adrian Mathis.
Very well, that can be received as well.
And then lastly, the state would like to move into evidence Exhibit 331, which would be a copy of Miss Adrian Mathis's part of her testimony, federal testimony in Mr. Boyd's case. I'd like to make that Exhibit 331.
Okay. Let it be received and read.
And we would ask for permission to publish it to the jury.
You have permission.
And so, in doing that, we'd like to have Investigator Childers play the role of Adrian Mathis.
Very well.
The court, call your next witness, Mr. Stone. Mr. Stone, the United States calls Nicole Mathis. Adrian Nicole Mathis, plaintiff's witness sworn. Courtroom deputy, would you please state and spell your name for the record? Witness, Adrian Mathis.
Adrian Mathis, ADRIENNEMATHIS.
Direct examination by Mr. Stone. Question. Good morning, Miss Mathis.
Good morning.
Do you go by a nickname besides Adrian?
Nicole.
And could you spell Nicole for the court reporter?
Nicole.
And drawing your attention back to the weekend of January 6th through January 8th, 2007, were you in your car? Did you have control of your car, or did somebody else borrow it?
On what date?
You're going to have to tell me. I'm just trying to draw you back to the general weekend, which is the weekend of roughly January 6th through January 8th. January 6th would be a Friday.
Yes, somebody borrowed it.
Okay, who borrowed your car?
Eric Boyd.
Your cousin?
Yes.
The defendant in the courtroom?
Yes.
Do you remember what day he borrowed your car?
Either Thursday or Friday.
Thursday would be the 5th of January. Friday would be the 6th.
Yes.
Excuse me, Friday would be the 5th. Saturday would be the 6th. You don't remember?
Yeah.
I've got a calendar here. You don't have any reason to disagree with that.
It's no response.
No response. This is January 7th calendar. I'm sorry, this is January 07 calendar. Friday's the 5th, Saturday's the 6th.
It was the 4th or the 5th.
You may not remember, as you said, whether it was Thursday or Friday. Was it morning, evening, night?
I can't remember.
Can't remember that? And when is the next time you saw the car?
When it was broke down on Monday, I believe.
I don't know if I've offered you this. So the following Monday, that would have been January the 8th?
Yes.
You retrieved your car?
Yes, we'll try to.
So you were trying to get your belongings out?
Yes.
And did you find some of your CDs?
Yes.
Did you find anything else in the car?
Yes, a sandwich bag full of bullets.
A clear sandwich bag
Yes.
of bullets?
Yes.
Could you describe the size of the bullets? Use whatever reference, an ink pen, your fingers, whatever.
They were about this long.
You're showing about, what, half the length of your pinky finger?
Yes.
And how big around compared to your pinky finger?
Probably a little thinner than my pinky, maybe.
And I noticed, would you agree with me, you sort of have long, delicate, thin fingers?
Yes.
And what did you do with those bullets?
I threw them out.
That is Exhibit 333.
Anything further?
Your Honor, with that, the state of Tennessee would rest.
All right, ladies and gentlemen, the state has rested its case in chief. That means there are a couple of things the court has to pick up outside your presence. Please go with your... Oh, I have one thing to read to you, man. Before you leave, I'll read this to you. Witness Adrian Mathis testified as a witness for the state. The state has introduced a numbered exhibit transcript of testimony she previously made in federal court. During the state's examination of Ms. Mathis, however, she was also asked about statements she made in other state court proceedings. As these statements have not been entered as a numbered exhibit by the court, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. All right. All right, you can, we'll go now with the court officer and we'll bring you back in. Oh, don't discuss the case yet. There's no time. You can be seated. Mr. Frazier, do you want to present your Rule 29 motion?
Yes, Your Honor. As to the Rule 29 motion, we would move to dismiss, and specifically in regards to the premeditated counts of the indictment, we don't think that the state has proven that Mr. Boyd premeditated, planned, or killed either victim, or that I don't believe that they've shown how he shared in the intent of his co-defendants. In regards to the felony murder and especially aggravated robbery, again, Your Honor, we don't feel that they have shown that he was present or shared the intent of the principals. There's been no evidence that he was present at the carjacking, Your Honor, specifically as to the especially aggravated robbery. As to the felony murder through the rapes, Your Honor, there is absolutely no evidence that he participated in any of the rapes of either of the victims in this case. And the felony murder through theft, again, there's been no evidence presented by the state that he participated in the thefts. I guess the only rebuttal that the state would have to that is that, according to Mr. Thomas, if he's to be credited, he drove, Mr. Boyd drove the SUV. And then specifically looking at the idea of criminal responsibility, Your Honor, under 39-11-402, I would point out that the defendant must solicit, direct, aid, or attempt to aid another person to commit the offense. And we just feel that there has not been sufficient proof in this case in that regard, Your Honor. And also, I would like to point out that the proof in this case, specifically as to Miss Christian's time of death, is that sometime between Sunday to Monday, and there is absolutely no evidence in the record that Mr. Boyd was present at that point in time. In fact, I believe the evidence would support that all the other co-defendants were present during that, there on Sunday, certainly. So I think given the nature of the proof that has come out against Mr. Boyd, we are asking that the court dismiss the case.
Your Honor, in approaching this case, we believe that the way to analyze whether or not there is sufficient evidence to sustain these charges against Mr. Boyd is that instead of looking at all the evidence together, we submit that that is not the way to look at it. We think that the first question is to look to see whether or not it has been proven to Your Honor's satisfaction of whether or not these crimes have been committed. And we believe that the evidence supports that the crime of especially aggravated robbery has been established against Ms. Shannon Christian. The proof has been that her property was recovered in the house at Chipman Street. Her property was also observed up in Kentucky. The proof has been that that these defendants exercised control over her vehicle. We believe that the proof in the record establishes that the crime of especially aggravated robbery was committed against Mr. Newsom, in that his property was recovered in Chipman Street. We believe that the especially aggravated kidnapping proof has been established that that crime was committed against Ms. Christian, and that's from the autopsy. You see that she is bound, she has been confined in the trash can. The proof that the especially aggravated kidnapping has been committed against Mr. Newsom, again, the proof from the autopsy was that he was bound. His arms were bound, his legs were bound. The proof of aggravated rape has been established that the oral rape was committed against Ms. Christian through Dr. Malusnik's testimony, and Jennifer Millsaps. The proof of a aggravated rape vaginally was established through Dr. Malusnik and Jennifer Millsaps. Her rape was established through Dr. Malusnik and Jennifer Millsaps of an anal rape. The anal rape of Christian Newsom was established through Dr. Malusnik. So we believe that there is evidence in this record to support that these crimes were committed against these victims, and clearly, I apologize, clearly the murder was committed. Clearly, under the definition of premeditated, premeditated act is one done after exercise of reflection. The fact that Mr. Newsom was bound and that he was shot 3 times, there's been absolutely no proof that he was armed. So we believe that his killing was a premeditated act. We think that his killing was committed during the commission of the felonies, kidnapping, rape, robbery, and the theft. Ms. Christian, her killing was premeditated in that she was bound and stuffed in a trash can after having a trash bag being placed over her face. Those are all premeditated acts, and she dies from that. She also dies in the commission of these felonies and thefts. So the question, those crimes were committed. Well, the next question is whether or not the state has shown that Mr. Boyd is criminally responsible for these acts. And we believe that the testimony, all the testimony taken together, establishes that there were 5 individuals at Chipman Street that's responsible for the crimes that were committed against Ms. Christian and Mr. Newsom. The testimony from Mr. Xavier Jenkins was that he saw the white vehicle parked behind the 4Runner at around 12:30 a.m., and that is corroborated by the cell phone tower expert who testified that the phone call that Ms. Christian made at 12:33 was made in the area of Cherry Street. Mr. Jenkins identified the white vehicle, and that white vehicle is Adrian Mathis's vehicle, and that is the vehicle that Adrian Mathis loaned to her cousin, Eric Boyd. That's the same vehicle that she found a bag of small bullets in when she got the car back on Monday. And then that taken into concert with Mr. Thomas's testimony that he observed Mr. Boyd walking Chris Newsom into the house in the sunroom, that he observed Mr. Boyd walking Chris Newsom out of the house, takes him to the loading docks, sees 3 flashes, comes back, gets the gasoline can, and sees a whoosh. And that Mr. Boyd comes back to the house, still driving Miss Christian's vehicle, and that Mr. Boyd does enter the bedroom where Miss Christian is. We believe that his testimony, coupled with Xavier Jenkins' testimony, coupled with Adrian Mathis's testimony, coupled with the cell phone expert's testimony, establishes that Mr. Boyd is acting in concert with his co-defendants, that Mr. Boyd is acting with the intent to promote or assist the commission of the crimes against Mr. Newsom and Miss Christian. The reason why he is responsible for every single crime that happens to Miss Christian is under the concept of natural and probable consequences, which is included in the instruction for criminal responsibility. He started the ball rolling. He started these violent crimes. But for him, they would not have had a car to get to Washington Ridge Apartments. And when he brings Chris in, who is bound, and he kills Chris, and he goes back to the bedroom and tells Mr. Davidson that it is done, the natural and probable consequences would be that Miss Christian is also going to be killed. So for all of those reasons, we would ask that the Rule 29 motion be denied.
Your Honor, I understand that the standard that the court has to view this motion is in the light most favorable to the state as far as the evidence goes. Again, we've already stated our reasons why we think it should be dismissed.
Thank you. It is true that at this point in the trial, the court must look at the case in the light most favorable to the state and grant to the state all reasonable inferences to be drawn from the evidence presented. In this case, one way to look at it is that from the standpoint of the witnesses and the evidence that's been presented, you have George Thomas testifying that he was at the Chipping Street address when the others came in. He testified that Thomas Coggins came in first, then the female victim, Shannon, came in next, then Newsom, then Boyd. And Marcus Davidson took Shannon to the front bedroom. And it all proceeds from there. Of course, there's also testimony that they were in the 4Runner that belonged to Shannon. So it's certainly a fair inference that Boyd came with them in the 4Runner. So Boyd is involved in it from the very beginning, and he has to take his fair share of everything that happened. Certainly the evidence is certainly sufficient to enable or convince a rational trial of fact that all of the crimes charged did in fact occur. And this court would find that it is a fair inference that Mr. Boyd was a part of the entire matter and is responsible, criminally responsible for everything that happened. So the court would find that rational trier of fact could find the defendant guilty beyond any reasonable doubt of all the offenses charged. Accordingly, the Rule 29 motion is respectfully denied. And we need to get the moment colloquy on the record. This court references the judge to just sit at the council table, pull the mic over so it's getting on the record. He doesn't have to be sworn in. He just is showing the essentials of his right to testify and try not to testify.
Yes, Your Honor.
Mr. Board, one of the questions we have to address is whether you want to testify in this trial or not testify. In preparation for this trial, have you and I sat down and discussed your right to testify?
Yes, sir.
Have we discussed some of the good reasons why we might want to testify, as well as some of the consequences if you were to choose not to testify?
Yes, sir.
Have we also discussed your right to not testify and the fact that you are presumed innocent in this case,
Yes, sir.
and that the state may not comment on your right to your decision not to testify?
Yes, sir.
And now, just a second, I'm actually looking for, I've got MoMA right in front of me, and I'm looking for the language specifically as to the colloquy. Here it is. All right. And again, you understand that you have the right to not testify, correct?
Yes, sir.
And that the court may not draw any inferences from your failure to testify.
Yes, sir.
You also have the right to testify, and if you wish to exercise that right, nobody can prevent you from testifying if you choose to.
That is correct.
And you have consulted with me in making that decision as to whether you want to testify or not testify. Is that correct?
That is correct.
We again have discussed the advantages and disadvantages of testifying,
Yes.
as well as the advantages and disadvantages of not testifying.
Yes.
And the decision that you're making in this case, is that a voluntary decision?
Yes, sir.
And that it's your personal decision as to what you feel you should do. Is that correct?
That is correct.
Have you made a decision about whether you want to testify or not testify in this case?
Yes.
And what is your decision?
I will not testify.
Does that satisfy the colloquy?
I think that takes me.
Yes, out of an abundance of caution, the state had filed a notice of impeachment, and that may be in the file, setting forth that if Mr. Boyd chose to testify, the state would seek to impeach him with his prior convictions for robbery. The sentence end date, according to TDOC, was 2001. This crime happened in 2007. So the state's position would be that, first of all, they are prior convictions involving dishonesty because they are robberies. And also, if he was released in 2001, then that would be within a 10-year time frame.
But he's not testifying.
Right, I just wanted to put that on the record that...
And if we're putting things on the record, again, we would have objected, given the nature of these charges and these crimes, and found that our position would be that they would have been prejudicial. Whatever decision the court would have made under those circumstances. But obviously, we don't need to go into that argument.
Well, he's not testifying, so it's not going to
Just, I think that we probably still need a ruling as to whether or not Your Honor would permit us to introduce him.
Okay, it is a felony involving credibility within 10 years, of course. Ruling would be that they would be admitted.
I think we would have to look at the date that the action was commenced against my client, Your Honor, and that would be 2017.
I thought the 10 years was measured from the time of release that he served the sentence.
Well, they're not impeaching him on his federal cases. It's state cases.
We would still say that robberies are...
Feel like we're opening a can of worms.
Well, to the extent that I can see what you've got, my general rule would be that they are inadmissible. However, we're not actually taking this step, so all of the details are not being fleshed out, and I can't really make a decision without making a decision.
Yes, sir.
So I don't think we really have to clarify this any further. He's not testifying, therefore the impeachment evidence will not come in.
Yes, sir.
All right?
It's fine with us, Your Honor.
Now that was just a notice you filed, that's not part of the record, it's not something that's...
No, sir.
Now, is the state ready to argue now?
Yes, Your Honor.
Is the defense ready to argue now?
The only question I have, I'm assuming that after we do arguments, we're going to go straight into the jury instructions? Is that
Yes.
correct?
Yes. Well, I can, if we need to, I'll take over the
Well, no, can we approach real quick?
All right. State ready?
State's ready.
Defense ready.
Yes, Your Honor.
Ready to jury. You can be seated. State ready to call?
Yes, sir.
Defense ready to call?
Yes, Your Honor.
Mr. Frazier?
Yes, Your Honor. Your Honor, given the weight of evidence that the state of Tennessee has presented against my client, at this time the defense rests, Your Honor.
Thank you. All right, ladies and gentlemen, the defense has rested. That means the proof portion of the trial is over. The next stage of the trial are the arguments of counsel. Following that will be the instructions that the court will give you for your deliberations. The state will have a closing argument, and then the defense will have a closing argument. And then because the state has the burden of proof, the state will have the final argument. Gentlemen?
Thank you.